Welcome, everybody. Today we're going to talk about an EB-2 national interest waiver case that was denied by USCIS, and they subsequently filed a mandamus lawsuit. And I want to take a look at this lawsuit. So it was recently filed on 3/17/25, and it was filed in the District Court of Columbia. And you've seen a lot of these cases, whether that's mandamus, EB-2 NIW, that is filed in the District of Columbia. One thing that I notice about this specific case is that this wasn't for delay. Like, we've seen a lot of cases where plaintiff is suing because they haven't made a decision on the I-130 or rather various other immigration benefit forms. But this one is that USCIS actually denied the EB-2 NIW, the EB-2 national interest waiver, and after the denial is where they're filing a lawsuit. I don't really know if the plaintiff is going to be able to win this lawsuit, because I have not seen that type of lawsuits. Mostly, what we're seeing is basically about delays. Okay, let's take a look at the specific of this case, just sort of jump into this specific lawsuit. So here is the plaintiff, and then it says it is a complaint for declaratory and injunctive relief and a writ for mandamus. And as we've seen in other lawsuits, they name all kinds of parties that was involved from the government side as defendants. So we have quite a bit of parties, and we'll go into that later as we dive in more into the complaint. So just some preliminary statement that they had sent in the complaint. Here's the plaintiff. It's a plaintiff with individual. They're saying it's a plaintiff with individual exceptional ability that has made a significant contribution in the field of business. So this person has filed an EB-2 NIW for a national interest waiver, and the USCIS denied his petition. And then they're saying that the plaintiff filed, again, the EB-2 NIW seeking a classification as an alien of exceptional ability in the field of multi-level marketing. And they're saying that despite extensive evidence of his qualification and national importance of his work, USCIS denied plaintiff's petition. I mean, the EB-2 NIW, based on just the latest data, the approval rate has really been declining. And again, they're saying in denying the I-140, defendant USCIS determined that the plaintiff failed to establish eligibility for a second preference classification. And then they're saying that the denial is arbitrary, capricious, and contrary to evidence presented. And then they're saying that the USCIS failed to recognize a plaintiff as a professional holding an advanced degree, and then instead solely validating his eligibility as an alien of exceptional ability. They're saying all kinds of stuff. So additionally, they're saying the USCIS reviewed the review ignored compelling evidence of the broader implication of the work, and they're saying the actions brought against the defendant for declaratory judgment, injunctive relief, and review of the agency action under the administrative procedure. And we have seen a lot of the lawsuits that are brought under the APA. The statement of facts, like I mentioned, they filed an I-140 for under an immigrant visa under the employment-based. So the EB-2 is the employment-based second preference category, and that waives the labor certification. They're saying plaintiff applied for a waiver of the requirement to obtain a labor certificate. So it pretty much is the labor certification waiver that happens with EB-2 NIW, because the professional field is in the national interest. And they're saying he submitted over 600 pages of evidence, and then they're saying that it had include evidence that he had advanced degree, alien of exceptional ability, and that he had advanced degree, documentation over 20 years of professional experience as a founder, evidence of holding license and professional certification, recognition in his achievement, and said he had command of salary that demonstrated his exceptional ability, evidence of membership in a professional association. There's expert opinion letters, then he received an RFE, which is normally the case with the EB-2 NIW, that the USCIS do send out an RFE, and then the defendant USCIS found in his RFE that the plaintiff did not establish that he met any of the 6 statutory requirements. I guess that's pretty much what the RFE has said. Then they're saying that the RFE was generic. So the generic nature of the RFE issued to the defendant made it clear that a meaningful analysis of the evidence was never conducted. There was flawed analysis. The agency repeatedly disregarded letters provided by experts. Then they're saying that the plaintiff submitted, so he responded to the RFE and he submitted again evidentiary packet over 200 pages addressing some of the inefficiencies outlined in the defendant's USCIS RFE, and then they're saying that on January 21st, 2025, they denied his EB-2 NIW petition. So again, this lawsuit is kind of unique because usually you see the mandamus lawsuit because, something has been pending for a very long time, right? So for example, an I-130 is pending a couple years more than the historical average, and they filed a mandamus lawsuit for them to make a decision. So like what I would have seen most likely in an EB-2 NIW case is that, somebody submitted an EB-2 NIW and is lingering there for a very long time, and you want the government to take an action on the EB-2 NIW. You don't necessarily see a case where the government has taken an action and then you don't like the action that the government is taking or how they approved it or denied it. Well, most likely you're not going to file if they approved it. So basically, if they denied it and you're filing a lawsuit, I don't know what the outcome of this lawsuit is going to be because, most likely you're filing a mandamus lawsuit for the government to take an action. But we'll keep an eye on this lawsuit to see where it goes. So again, just getting back to it, says the first denial notice clearly indicates that the USCIS failed to meaningfully review the RFE submission. They didn't conduct a thorough analysis of the extensive submission. And they're saying the USCIS ignored compelling evidence of broader implications of the work. Okay, let's just take a look. They're saying the court has subject matter jurisdiction over this claim, and they're saying the venue is proper. So we did talk about the parties a little bit. So again, when it comes to the defendants, they do name quite a bit of defendants. So we have the plaintiff here, and the defendant is the Secretary of the Department of Homeland Security. Then they had another defendant. It's a director, senior official within the USCIS. Another defendant they named is a director of the Texas Service Center. Another defendant is the Attorney General of the U.S. And so they're saying that the plaintiff has exhausted all remedies. And again, plaintiff is not required to exhaust any administrative remedies before bringing this complaint because there is not a statutory appeal for this question. And then they're saying the denial of the EB-2 NIW by the USCIS is the final agency action. And some of the counts are saying is the violation of the APA, injunctive relief for the Administrative Procedure Act, and some of the relief that I requested, I thought it was interesting. So let's just dive into it a little bit. They're saying that declare the denial of the plaintiff's EB-2 NIW was erroneous, arbitrary, and capricious, and abuse of discretion, and not otherwise in accordance with law and violates a due process. This is, I think, one of the very few ones that I've seen where they're actually suing. There's a lawsuit filed because of a denial. Again, like I mentioned, most of the immigration lawsuits for mandamus is because something is just sitting there and they're not taking action, but not because of a denial. And okay, so let's take a look at the issue. They're asking the court to issue an order directing the defendant USCIS to reopen the plaintiff's EB-2 NIW 140 case and issue a decision that's compliant with legal standards. It's very interesting is how they phrase it. They wanted them to reopen and issue a decision, but it doesn't. They want the EB-2 NIW to be approved. That's what they want. But I don't know if this lawsuit is going to go anywhere because you can't compel USCIS to make a favorable decision on an EB-2 NIW. They have a lot of discretion on that, and with some of the recent Supreme Court rulings, they have a lot of discretion on whether to approve it. Again, that's just my opinion. This is again. someone that's reading, court records that are open to the public and then interpreting it, and then just making my own opinions about after reading it. And then saying they issue an order directing defendants to complete the processing of the EB-2 NIW within a reasonable period of time. And they're saying retain the jurisdiction over this action to monitor and enforce defendants' compliance, and then the grant attorney's fees. I mean, this was just filed, I guess in March 2025, and I have not seen any movement in this case, but we'll keep an eye on it and see where this goes. Thank you for listening. I appreciate it. If you like this, give me a thumbs up, like, subscribe, and we will see what other new immigration lawsuits are coming up. Thank you so much. Bye-bye.